that they can join us. So good evening, everyone, and welcome to tonight's presentation on estate planning with blended families. It's a good topic, and I think we'll get a lot out of tonight's session. My name is Anna Silverman, and I am a licensed funeral pre-planner with Hulse, Playfair McGarry. As we know, or as you're going to discover, estate planning is a way to ensure that your wishes are honored. And when we're dealing with blended families, it becomes a little bit more crucial. This evening, we'll explore the unique challenges that blended families face, from inheritance issues to balancing the needs of current spouses, children, stepchildren, and new partners. We'll also discuss the complexities that the role in the financial funeral arrangements and final arrangements that your families want to make. For those who may not know, November is Make a Will Month. We hope that tonight's session will encourage you to discuss, prioritize, revisit, and update your will with your loved ones. And remember, our team at Hulse, Playfair McGarry, we're here to assist you in any way that we can in this process. We have a few housekeeping items tonight. This is a virtual seminar. So to help minimize disruptions, all microphones will be muted and cameras will be off. We're recording this session and we'll send everyone here a link in case you've missed this as we're going through it. And there will be a Q&A following the presentation. We're grateful to have you with us tonight, and our goal is to provide you information and insights and tools that will help you make informed decisions for you and your family. If you have any questions or feedbacks on tonight's presentation, please feel free to reach out to us at info@hpmcgarry.ca. Without further ado, let me introduce our speakers from Mann Lawyers. We are thrilled to have with us once again Kate Wright, partner specializing in family law, wills, and estates, and her colleague Brandon Doughty, lawyer in estate and wills. And Kate and Brandon, thank you for joining us again this evening, and I'm going to turn the floor over to you.
Thank you, Anna. It's wonderful to be here with you again and to talk about estate planning for blended families, which is a topic that's really near and dear to my heart. I'm a partner here at Mann Lawyers, and I practice in wills and estates and family law. So I see this issue from many different angles. So hopefully tonight we can provide you with some food for thought, get you thinking about some of the issues or some of the unique challenges that you might face trying to work out your estate plan as a blended family. So as I start to share my slides, I'll turn it over to Brandon to give a quick introduction of himself as well.
Thank you, Kate. Thanks for the introduction. My name is Brandon. I practice wills and estates and real estate as well. I am also an associate at Mann Lawyers, and I practice out of our offices in Ottawa and Perth, work with a wide variety of clients who have different needs, and really looking forward to presenting on this topic with the panelists up here. There's a lot of complexities that go into an estate plan, and hopefully we can provide a bit of clarity and get the wheels turning, as they say, in terms of what folks may need in their actual plan. So thanks for being with us tonight, and we're looking forward to spreading hopefully some good general information to get you thinking about your own plan.
Thanks, Brandon. So just to get us started off the top, I do want to remind people that the information we're going to give tonight is intended to be general in nature. So we're not giving legal advice, we're giving you some information. You may have questions, and there will be opportunity to put questions in the chat, and we'll try and get to those later. But just a reminder to keep your questions as general as possible. We can't provide any information on specific sets of facts. So starting off, why have an estate plan?
I'll take it over there, Kate. So
There you go.
Perfect. So an estate plan, what it does is it really outlines how you want your assets distributed after your death, ensuring your wishes are respected. Proper estate planning can help reduce the taxes and fees that your estate might incur, leaving more for your beneficiaries. By clearly stating your intentions, an estate plan can help prevent misunderstandings and conflicts among family members. And a proper estate plan can also ensure that your loved ones are taken care of according to your wishes, including appointing guardians for minor children and making provisions for dependents as applicable. Beyond a will, an estate plan includes other critical documents like powers of attorney for personal care and property, which are essential if you become incapacitated. Creating an estate plan might seem daunting, but it's one of the best gifts you can give your loved ones, providing them with clarity and reducing their stress during a difficult time. So in this presentation, we will talk about these tools and how they can be used in the context of a blended family, where there are unique considerations in preparing an estate plan. So an estate plan can be for everyone, as typically it is a comprehensive set of legal documents and instructions that outline how you want your assets and affairs handled after your death, or if you become incapacitated. So this can include a number of things, such as a will, which a will typically specifies how your assets should be distributed, names an executor to manage your estate, and again, can appoint guardians for minor children. When we're thinking of power of attorney documents, we're thinking of two typically. We're thinking of a power of attorney for personal care and for property. So in brief, a power of attorney for personal care typically appoints someone to make healthcare and personal care decisions on your behalf if you are unable to do so. And a power of attorney for property, typically you're appointing someone to manage your financial affairs. When we're thinking of trusts in an estate plan, so typically these are set up to manage and protect assets for beneficiaries, such as minor children or individuals who may not be able to manage their assets themselves. When we're thinking of beneficiary designations, these are used for assets like life insurance policies and retirement accounts, ensuring they go directly to the named beneficiaries without going through probate. And as we'll learn further on in the presentation, when we're thinking about funeral arrangements, some estate plans include specific instructions for funeral and burial arrangements to ensure your wishes are followed and to ease the burden on your loved ones.
So why are we choosing to focus on blended families tonight? What makes blended families unique? These are families that I work with regularly in my practice. And I would say the biggest challenge in dealing with blended families from an estate planning perspective is that you can often have competing obligations. So you may have individuals that you owe a legal obligation to, so children, spouse, you may have an obligation to provide support for them, or it could be a question of moral obligations. So you have children who are adults and may be financially independent, and you may no longer be supporting them, but you have a desire to provide something for them on your death. So if we just look at a couple of examples of some, typical blended families and where the competing obligations might arise, you may have a situation where you have a second spouse and you have children from a prior relationship. So if those children are not financially independent adults, so whether they're minors or they're still dependent on you for support in some fashion, you have a legal obligation to make sure that they are adequately provided for. This is the language that is used in the legislation that talks about support for dependents. So you have an obligation to make sure that those children are adequately provided for on death. And you may also potentially have a competing claim from a spouse. You may also owe a legal obligation to them for support. So we'll talk more about how this works later on in the presentation, but it's always important to remember that support for children takes priority over support for spouses. That's dependent children, not independent adults. So you may also have a scenario where perhaps your children are financially independent, they're adults, you may have a second spouse, but you may still owe a legal obligation to your prior spouse. So it's very possible that this is going to be identified in a separation agreement. And very often in those separation agreements, there will be an obligation to secure that support via some sort of plan, whether it's a life insurance policy, that's the most typical. Although if life insurance is not possible, we have had contracts that that I've done as a family lawyer, I've seen in my estate planning work, where support is secured by passing on a different type of asset. So the person who is preparing your estate plan should be looking at all of your domestic contracts, whether that's a separation agreement or a marriage contract or a cohabitation agreement, to see what obligations you've set out and what considerations need to be had about obligations that might have been released, perhaps. When you're doing estate planning, whether you're a blended family or not, you always want to be thinking about tax efficiency. This can become even more important to turn your mind to for blended families. If you are giving assets to individuals where they may not be responsible for the tax burden as a result of the gift of that asset. So because there's a deemed disposition of your assets on death, which means it's like you've sold all your assets on death, there's going to be some tax implications. And we'll get into more detail about this later in the presentation. But this is just to highlight some of the things as a blended family you want to be thinking about. And then, of course, in any family, things evolve over time. For blended families, your obligations and to whom you owe those obligations, be it legal or moral, may change over time. It's going to evolve. So I always encourage clients, no matter what, to be reviewing their estate plan regularly. But this may become even more important for blended families, where some of those changes might happen on a more regular basis. So what happens if you don't have an estate plan? What happens if you don't have a will? What happens if you haven't thought of any of these things? So if you don't have a will, for example, there is a piece of legislation called the Succession Law Reform Act that is going to determine who the beneficiaries of your estate will be. So it will set out, if you have a spouse and children, what each of them are to receive. So if you have a spouse, and in this case, I'm going to differentiate throughout our presentation what I mean, who is considered a spouse under different pieces of legislation. So in Ontario, you can be a married spouse or you can be a common law spouse. And as a married spouse, you will be entitled to certain things. And as a common law spouse, there are some of those things you're entitled to, but some you are not. So for the purposes of the Succession Law Reform Act, as it relates to beneficiaries of an estate, which is different than applying for support, only married spouses are entitled to be given something from an estate automatically on an intestacy. Intestacy is dying without a will. So a married spouse is going to be entitled to a preferential share of the estate, and then the estate is going to be divided between the spouse and the children, depending on how many children there are. And then if there is no spouse, if there's no married spouse, it goes to children. So if you're a common law spouse, you're not going to be included in that. And then it goes on and on from there to depending on which next of kin are alive. So this is very tricky for those in a blended family because you're not getting to choose who your beneficiaries are, and it may give rise to claims against your estate if someone to whom you have a legal obligation, like perhaps a common law spouse, is not included. So in that case, a common law spouse would have to look to separate provisions under the same piece of legislation and make a claim for what we call dependence relief or support, essentially. So the other thing is you do not get to choose who your estate trustee is going to be. And this is important for everyone, no matter what, if they're in a blended family or not. But it can be even more crucial in a blended family because you want to make sure that the person who is administering your estate is going to have the skills needed to navigate any of the difficult feelings or emotions. They're going to be able to navigate any claims that might arise. So by not having a will, you're not going to necessarily be able to have the person that you would choose as your estate trustee. And if someone is going to bring a claim against the estate, so if a common law spouse is going to bring a claim against the estate or a married spouse, whatever, they are not entitled to then act as the estate trustee. So if the plan doesn't work and you would have wanted them as the executor, they're not going to be able to do that because now they're sort of adverse in interest to the estate. So that can be problematic. The other thing that we want to sort of touch on is what obligations we might have to children, but also possibly to stepchildren. So it is possible to stand what we call in loco parentis to stepchildren, meaning that you may have an obligation to provide support for them as well. And if they are not provided for on death because they are not your biological children, and you would have intended to give them something, leave them something from your estate, by not having a will, they're not going to be included in any distribution of your estate. And again, this could potentially give rise to litigation. And often when I talk with clients, it's not just that they have a legal obligation to stepchildren. Many people do want to benefit their stepchildren from their estate. And so the law does not provide for that if those children are not, if they're not adopted, if they truly are, stepchildren, that's the relationship. They'll only be included if it's done so in a valid will. So I'll just highlight quickly some of the differences between married spouses and common law spouses. So we touched already on the fact that a married spouse gets a preferential share of the estate if there is no will. So that value is $350,000 that they would be entitled to off the top, and then they would share the rest with children, assuming that there's children. If there's no children, a married spouse would be the only beneficiary. Then there's claims for equalization. So similar to when a couple separates, on death, a spouse can elect either to take what they've received under a will. This is a married spouse, again, to be clear. A married spouse can take what they've received under the will, or they can elect or take what they've received under an intestacy, or they can elect for an equalization, which is a division of the assets that's accumulated between the date of marriage and the date of death. So that, again, is only a claim that's available to married spouses. And then common law spouses and married spouses alike can make a claim for dependence relief. So that's support from the estate. So those are going to be the sort of the three ways that a married spouse or a common law spouse, depending on where they fall, can benefit from the estate if there's no will in place. So, and again, touching on the taxes, if you don't have a will, you are going to miss the opportunity to do some of that important tax planning that we'll touch on a little bit more. I'll turn it
Thanks, Kate.
over to Brandon, yes, to talk about the will and how it works.
Much appreciated. That was great. So as Kate was sort of hinting to there, one of the cornerstones of the estate plan is, of course, your will. So as some of you may know, a will allows you to name your beneficiaries, but more than that, it also allows you to make important appointments such as an executor, or more broadly referred to as the estate trustee, and guardians for minor children if necessary. It also gives you an opportunity to revoke outdated wills and or codicils as applicable. And in the context of a blended family, a will could actually be very crucial to ensure that your assets are distributed according to your wishes, and taking into account some of the unique dynamics and relationships within the family, as Kate kind of hinted at in her previous slide. So in the presentation, we are going to be spending quite a bit of time talking about beneficiaries, and the choice of your executor is a very important one and can be challenging in the context of blended families. Your executor, for example, could be tasked with, all the usual things like paying debts, filing taxes, and distributing your estate. But if there's any conflict about your estate or within the estate itself, your executor would have to deal with claims against the estate. So ultimately, what you could consider is whether your executor is someone that can actually navigate those claims. If a spouse or adult child, for example, is appointed but want to bring a claim against the estate on their own behalf if they think they're entitled, they would likely need to renounce as in their role as executor if you've appointed them. So just some things to consider in the context of what is a will in a blended family. So in your will, you may need to actually create trusts, either for minor children or for a spouse. So it is important to consider the financial well-being of your spouse. As Kate had mentioned, you have an obligation to care and look out for them. A well-structured will, for example, can ensure that your spouse is taken care of, while also protecting the inheritance rights of your children from previous relationships, for example. A spousal trust can allow you to ensure your spouse benefits from income and capital of the trust during their lifetime, but provides, in the context of a will, for a gift over if your spouse were to pass away. This could be all or part of the estate, just as an example. And in that scenario, you may need to consider who the executor is and who's actually going to manage the trust. They may not be one and the same person. A will can ensure that funds for minors are held in trust until a certain age. You can also, again, appoint a different trustee for those funds, or ensure any planning for incapable beneficiaries, such as a Henson Trust, just as an example, is contemplated in your plan. And if you have minor children, your will can designate guardians to care for them. This is especially important in the context of blended families, where the biological parent may not be the current spouse. In your will, you can also address gifts or loans and provide for those to be equalized. So providing money during your lifetime and how that actually is accounted for in your estate. So a lot of folks obviously are very invested in personal effects, and they want that dealt with, properly in their will. So things like family heirlooms and or sentimental gifts, if those are contemplated in the will and, you get proper advice on that, this can help prevent disputes, especially in the context of blended families and, maybe estranged relatives, for example. In some cases, couples in blended families may choose to create, as an example, mutual wills. So there can be binding arrangements that ensure the surviving spouse cannot change the will after one partner's death, just as an example. This can also provide additional security for children from previous relationships. So ultimately, creating a will that addresses, these complexities of a blended family can be challenging. But it is essential to think about for ensuring not only that your wishes are respected and that your loved ones are provided for according to your intentions, while meeting any obligations you have to family members. So, you know, a lot of clients and folks will ask, do I need a lawyer to prepare a will? And the short answer is no, you do not. There's no legal requirement to hire a lawyer to prepare a will. Although, and as I'm going to try and stress here tonight to you, is that it is highly recommended, especially in the context of a blended family. And there are several reasons why. So as we sort of touched on already, blended families often have more typically complex relationships and inheritance issues. So a lawyer can help you navigate these potential complex issues to ensure that your will accurately reflects your wishes and fairly addresses the needs of all family members. This often arises, you know, in a consultation and trying to understand what your needs are and the needs of your family members. So a lawyer can ensure that your will complies with Ontario's legal requirements and can help you avoid any potential legal challenges in your estate. Lawyers can provide tailored advice and solutions, such as setting up trusts or creating mutual wills, as we touched on earlier, and ultimately to protect the interests of both your spouse and children from previous relationships when we're thinking about blended families. You know, do-it-yourself wills, as some people refer to, can sometimes lead to errors or omissions that might invalidate the document or lead to, unfortunately, unintended consequences. So a lawyer can help avoid these issues. Knowing that your will has been professionally prepared can provide peace of mind to you, and ultimately that your estate will be handled according to your wishes, reducing the likelihood of disputes among your family. So just for certainty, while it is possible to create a will on your own, the added complexities of a blended family make professional legal advice what I would suggest a wise investment. So when we're thinking about wills in the context of marriage and divorce, so for marriages occurring on or after January 1st, 2022, a will is no longer revoked by marriage. A will survives divorce, but the spouse is presumed to have predeceased the will maker. This prevents an ex-spouse, for example, from inheriting under the will unless explicitly stated otherwise. So as Kate had mentioned earlier, just talking about the Succession Law Reform Act, or SLRA for short, changes to the SLRA treat separation like a divorce if there is a court order, separation agreement, and the couple has been living apart for 3 years. So this ensures that a separated spouse does not inherit unless specifically included in the will. So what does this mean? It is important to consult a lawyer to determine if the amendments do apply to your circumstance or whether the previous version of the legislation would apply, which can impact your estate plan and the advice you receive. So ultimately, estate planning is crucial for blended families to ensure fair distribution among biological children, stepchildren, and current spouses. Trusts and specific bequests can help manage these complex family dynamics. Life changes such as marriage, divorce, or separation could necessitate updates to ensure your estate plan to reflect your current wishes and family situation. Ultimately, consulting with a lawyer can help you navigate these changes and ensure that your estate plan remains effective and legally sound.
Thanks, Brandon. So I just want to touch on a couple of things in this slide that come up regularly for me in my practice. So the rule about marriages no longer revoking wills on or after January 1, 2022. So I have had clients come to me, you know, all the way up to as recently as a couple months ago, saying, oh yeah, no worries, I do have a will, but we're just going to change it, we're just going to update it. And then, so I look at their will, which was prepared prior to 2022, and they're married since then. And I have to say to them, actually, you don't have a will, because immediately on marriage, your will was revoked. So there may be some of you out there who think that you have a current will and maybe it needs updating. But if you prepared that will and subsequently got married prior to Jan 1, 2022, that will was revoked on marriage. So I just want to make sure that's sort of crystal clear for people. Since January 1, 2022, if you got married and had a will prior, it's not revoked, but any marriage prior to that would have revoked the will. Also, the issue of separated spouses. So this can be a tricky one. So under the change to the legislation, you have to have been living separate and apart for 3 years, but that has to have occurred after January 1, 2022. So for example, if you separated in January of 2021, your spouse, if you would have been separated for 3 years now. If you don't have a separation agreement, if you don't have a court order, if you still have the same will that you had, or if you don't have a will, but you're still legally married, your spouse is still entitled to share in your estate if you passed away. So it's only if that separation has occurred after Jan 1, 2022 and has been for 3 years. So we're just coming up to January 1, 2025. So we're just getting into the place where this rule is going to kick in. There may be questions about, well, how do I know when I was separated? Like, what is the date of separation? And this is a question that comes up in family law all the time, because we need to know the date of separation to know what the valuation date is. This is a question of fact. In some cases, it's going to be quite obvious what the date of separation was, but sometimes it's not. I've seen people think that this date of separation was a couple of years apart, and you can wonder how that happens, but it does. And so it's a question of fact that really has to be determined, with advice, potentially from a family lawyer. But in some cases, it's obvious. But just so you know, for the purposes of this change, that separation has to be after Jan 1, 2022. So now we're going to move on to talking about your legal obligations versus testamentary freedom. So in Ontario, and this is not the same for all provinces, and to be clear, the advice that we're giving is related only to Ontario. I assume that people attending the presentation are from Ontario, but if you have, loved ones in another province, you can't just go and share, oh, I heard this great presentation, because every province is different. Wills and estates, family law, it's all governed by provincial legislation. But in Ontario, we generally have testamentary freedom, meaning that we can leave our assets to whomever we like, except if we owe a legal obligation to support someone. And a will cannot be used to avoid that. So just because you have a will, if you say, I'm going to leave it all to my one child, or I'm going to leave it all to charity or whatever, if you have a legal obligation to support, then you have to make sure that is covered off. So dependents under the SLRA are going to include your spouse. As I said earlier, this includes a 3-year common law spouse. So under the Family Law Act, you're considered to be common law once you have been in a cohabitating in a regular sort of relationship for a period of 3 years or more, or earlier if you do have a child together. So that's what's considered a common law spouse for the purposes of the Succession Law Reform Act as well. So your parents could be considered dependents, your children. So this would include, of course, minor children, but may also include adult children who aren't able to withdraw from support. So it could just be that they're in university. It could be that they have disabilities or are otherwise dependent, and can also include someone that you've treated as a child. So whether this is a stepchild or a niece or nephew that you've sort of treated as your own child, if that intention is there to treat them like your child, you may have an obligation to provide them with support. And then it would be brothers and sisters as well, could be considered dependents if you are providing with them with regular support prior to your death. And so there are some ways that we can address this in your estate plan. So what I try and do, with my clients is I look at, okay, let's figure out who your dependents are first. Do you owe any support under a separation agreement? Are you in a common law relationship? Are you also married? What does that look like? Children, as I said, have the priority. So providing support to children is going to take precedence. And so you're going to look at how old are your kids? What are their needs? What might you have to provide for them in order for those needs to be met? Now, in some cases, you may have a separation agreement with a prior spouse that talks about security for child support for children. So let's say you have an obligation to pay support for your minor children, and then your agreement also says you must have an insurance policy of X amount of dollars to secure that support if you die before your children are financially independent. That is not necessarily going to be considered adequate provision for your dependent children in the context of your estate distribution on death. That only secures the amount of support that you are obligated to have for your former spouse. Whether it's in trust or payable to your spouse directly, it doesn't really matter. That's just the amount you have to secure. Sorry, the lights are going out in the office. They're going to blink. Apologies. But that's the amount of support that you're going to have just to secure that. So if your estate is much bigger than that, you may also have to provide additional support or additional funds from your estate for that to be considered adequate provision. So you want to have that conversation with the person you're doing your estate planning with. The same thing would apply with spouses. So typically, if you have a former spouse and you secure support for that spouse pursuant to a separation agreement, that's going to be enough because the claim has otherwise been released. But if you have a second spouse, you're going to need to think about how you can balance what you may owe to children and what you may owe to a spouse. And we'll talk a little bit later too about domestic contracts and using those to help in the context of estate planning. So the legislation in Ontario that blended families need to be looking at is the Succession Law Reform Act, which we've talked about already a bit, and the Family Law Act. So I'm going to expand a little bit further on how the Family Law Act plays into this, because this really gets to the issue of the equalization claim that I talked about before. So if you are going through a separation and you have not reached an agreement with your spouse on how you're going to divide your former spouse, how you're going to divide up your property if you're married, and what the resolution of that claim is going to be. I do have clients who come to me and say, well, should I change my will? What should I do? How should I make sure, I'm covered? And so it may be that you should update your will at that point, but you need to be aware that any claims under the Family Law Act for equalization would continue until they're resolved, right? So there are limitation periods in the legislation that address this. And so what that means is that if you have a spouse from whom you have separated, they can bring a claim for equalization, and it has to be made, at least 6 years after the separation or 2 years after the date of divorce, whichever is earlier. If the spouse passes away, they have 6 months to bring a claim for equalization against the deceased person's estate. And so in doing that, even if you've changed your will, if they were the sole beneficiary before and now you've made it your kids, the spouse your former spouse who survives you can still apply to the court to have the property divided. So you want to be thinking about that as you're sort of updating your plan. So for some of my clients, it means they're doing one update while they're kind of going through the separation and maybe leaving certain things to their former spouse, but ensuring that anything that's going to their kids is going to be in a trust and maybe managed by someone other than their spouse if that's their wish. All right, so then let's chat about what are some of the other things that need to be considered if you're in a blended family. So we talked a little bit about stepchildren and standing in loco parentis. Standing in loco parentis means you stand in place of a parent, and you may have an obligation to support the person for whom you stand in place of a parent. So one of the ways in which we address those kinds of claims can be through a cohabitation agreement or a marriage contract, which will address whether or not couples who are bringing their families together are responsible for their spouse's children from a prior relationship. Having said that, child support is the right of the child. And if you sort of govern your relationship in such a way where even though you've put into a contract that you're not financially responsible for your stepchildren, if you are, buying things for them, if they're financially dependent on you, if you're sort of have blended finances within the family, even if you have that type of contract, it may be determined that you actually do have an obligation to support those kids. So ensuring that you're thinking about not just your children, but also stepchildren and how that impacts how you're setting up your estate plan. Brandon touched earlier on sort of some of the ways that spouses can work their plans together, and we'll get into a bit more of that in some later slides. But if you each want to be financially separate from each other and each want to be caring for only your children from your relationship in life and on death, you want to make sure that you're getting family law advice on your contract, as well as how to navigate, how to manage your finances on a day-to-day basis, so that there's no sort of impression that financial support exists. Okay, so what happens if you do not meet any of your obligations to your dependents and your estate? So as we've indicated, there's the possibility that a claim is going to be brought against your estate This could either be from a former spouse, a current spouse, or on behalf of minor children. So usually in that case, it's going to be a biological parent who's advancing a claim on behalf of minor children if they haven't received what they think they should from the estate. And there's a separate agency called the Office of the Children's Lawyer who will also get involved if there are claims for minors against someone's estate. So if these claims cannot be settled either through negotiation or mediation, then it's very likely there is going to be litigation, and that is very, very costly. A typical estate litigation claim going through all the way to trial or even settling before trial is going to cost tens of thousands of dollars to potentially hundreds of thousands of dollars, depending on the size of the estate and how entrenched people are in their positions. So we always want to make sure, like, yes, it's costly to prepare a will and to prepare powers of attorney, but not only are you giving a gift to your family of having a plan in place that can hopefully be upheld and be enforceable, you're also preserving your estate for the people who you have an obligation to support. You're also ensuring that, you know, if there is litigation, if you haven't properly set up your claim or addressed what the dependent needs are, there's a very good likelihood that there's going to be a lot of tension between family members. And that is certainly, I've seen families really, you know, fall apart over these types of things. And I have lots of clients who say to me, no, that will never be my family. That will never happen to us. You know, I think they'll get along. I said, that's great, but I've been doing it long enough to see what happens on the other side. So the other thing I encourage clients to do all the time to sort of help avoid any of this litigation or any of these problems arising after death is to speak with your family members about what your intentions are and about what your estate plan is. If you have, you know, children from separate families, and I'm not, you know, talking about minor children necessarily, but if you have adult children, you want to be talking with them about what the plan is, all of them together, so that there is an understanding and they have the opportunity to ask questions, because there's nothing worse than having a surprise or having lack of clarity when your loved one is already gone. The other problem that is created if there's litigation against your estate is that the distribution is going to be delayed. So some of these claims can take years before they're resolved. And during that time, none of the estate is going to be distributed. So all of your loved ones are missing out on the opportunity to benefit from what you've worked so hard during your lifetime to create. So this is a list of some of the planning tools we look at regularly for blended families. So ownership and designation. Ownership will dictate how assets pass on death. So when you look at your assets, if you own assets as joint tenants with a spouse, that will pass directly to them on your death outside of your estate plan. So it's important to understand how you own real property, to make sure you understand what that means. If you own property in your sole name, it passes to your estate, to your will, and would be distributed in those terms. If you own property as tenants in common, let's say 50-50, your 50% interest gets distributed in accordance with your will, And if you own it as joint tenants, as I said, it passes to the joint owner. So you have to examine this and think about, is that what I want? Is that what I intend? Is that still what I intend? And review it over time. The same applies to bank accounts. Bank accounts owned jointly with a spouse are going to pass directly. Now, I will often have clients ask me, oh, should I add my kids to title? Should I add my kids to the bank account? So the same rules about rights of survivorship don't necessarily apply when we're talking about property that is owned between a parent and an adult child. So that's the other thing you need to get advice on. You also need to consider, is it appropriate to be adding adult children to these assets? Because it now means they're owners. They have rights. They may have spouses that have rights. So that may not be what you're intending. So think about how you own title, particularly if you're if you have a spouse in a second relationship. For a lot of people, a house is their biggest asset. And so is it appropriate that you own that jointly with a spouse? And do you understand that that passes directly to them? Or do you have a different intention? The same thing goes for designation of assets. This is something you want to be reviewing regularly. So if you have separated, make sure you're reviewing your designations. Do not change any designations unless you speak with your family lawyer, because you may have an obligation to maintain those, but make sure you know how they're designated. And once you have signed your separation agreement, make sure you're talking with your estate lawyer at that point to make the proper designations, the proper updates on those assets. Brandon touched earlier on a spousal trust. So why do we talk about spousal trusts in the context of blended families? It's because we want to ensure that our spouse is cared for during their lifetime, but also to potentially protect what might be left over at the end to pass that on to, our children from a first marriage. So a spousal trust would operate so that the spouse is entitled to all of the capital and the income during their lifetime. But you could say, when my spouse passes away, I want whatever's left to go back to my kids. Now, a spousal trust is not going to be appropriate for everyone. Again, it depends how you own assets with a spouse and what your intentions are. And there's costs that go along with creating any of these trusts. So you have to think about whether or not it's the right tool for you, but it is an option. Some people will place a home in a spousal trust. So they'll leave the house that they own solely to their spouse, and they'll indicate that, that will be in trust for the spouse. You just have to be careful that any of the proceeds from that house, if it's sold before the surviving spouse is deceased, go back into the trust so you don't lose the tax benefits that you get from having a spousal trust. Other tool, a life interest. You can allow someone to have possession and use of property for their lifetime, after which it would pass on to somebody else. This can be very useful, for example, with a family cottage. So a lot of people, when they're in blended families, this can become a very tricky asset to deal with. But you could say, okay, I would like my spouse to have use of this cottage during his or her lifetime. And then on their death, I would like it to go to my kids. When you're setting up these kinds of trusts, you want to, or interests, you want to be thinking about who pays the expenses. So who's going to have to be responsible for the costs, any capital improvements that are required, etc., during the spouse's lifetime. So that's something you can discuss with your estate planning lawyer. Mutual wills is another thing that Brandon touched earlier. This makes it so you have a contractual obligation to maintain the current distribution of your will on the death of the first spouse. So, for example, if you say with your spouse, okay, when both of us are gone, we're going to leave everything to the 4 kids that we have together, 2 from that marriage, 2 from this marriage. If you don't have a mutual wills agreement and nothing is in trust, you've just left everything to your spouse, then your spouse can change their will on death. They can say, you know what? Those kids haven't really been visiting me. They haven't been taking care of me the way we thought they would. I think I'm just going to leave everything to my kids and I'm going to change my will. So that's if you have mirror wills. If you have mutual wills, you've created a contract that says, no, when one of us dies, that's it. We can't change it. During our lifetime, we can only change it with agreement between the 2 of us. And then when one of us is gone, we're stuck with whatever that distribution is. So that can be a useful tool. Again, not appropriate for everyone, every couple, but it can be helpful. Life insurance is a great way to, 1, have security for support, or to get some funds to a spouse outside of your estate, or funds to children outside of your estate. So it can provide an added flow of cash to your estate on death. And then domestic contracts. So when we talk about domestic contracts, we're talking about separation agreements, marriage contracts, and cohabitation agreements. So in a cohabitation agreement and a marriage contract, you can agree with your spouse what happens with your assets, both on separation and on death. So you can agree in a marriage contract, okay, you're going to leave me the house, you're going to leave me a life interest in the house, this is who's going to pay for it. We agree we're separate as to property. I don't get anything except what we've laid out in this agreement. This is how it applies on separation. This is how it applies on death. You can really be very creative with these contracts, and then that will help guide your estate lawyer as to what clauses should go into the will. Now, I love to have family lawyers preparing these contracts and estate planners working together before the cohabitation agreement or the marriage contract is done, to ensure that the estate planner is happy with the clauses that deal with death in the cohabitation agreement, to make sure that they can put all of that into a will and it's a reasonable plan and it's going to be something that's workable and there's not something that's been forgotten. So you can encourage your lawyers to speak to each other if they practice in different areas. The separation agreement is going to deal with the claims from a spouse whom you've separated from, and as I've already indicated, potentially deal with security for support. So I think that's usually a little bit more obvious to people how that fits into the context of the plan. But the marriage contract and cohabitation agreement can be really useful for setting out what everyone is entitled to. Now, I always give the caveat to clients as well. If you have a cohabitation agreement or marriage contract that releases spousal support, so says we're not responsible for support, including dependence relief, there are provisions in the Succession Law Reform Act that says a court can look beyond that agreement that says on death, they're not going to be entitled to support, and they can order it anyway. So it's difficult. I mean, you virtually can't contract out of support on death. You can have an agreement that addresses your intentions and your wish, but I do encourage people to think about, okay, if you pass away, what obligations might you have to a spouse, notwithstanding that you do have a marriage contract or cohabitation agreement. And I am going to turn it over to Brandon to talk a little bit about tax.
Thanks, Kate. That was great. And I think one of the things that, just thinking about real estate and joint assets and bank accounts, one of the things you touched on that I think is important for people is joint assets between adult children, I should say, and their parents. So, oftentimes we'll get a lot of questions from clients about, well, I have this bank account. I have it set up, my kid's helping me because they're my attorney for property, which we'll talk about a little bit further on in the presentation. But really, there is a special relationship between adult children and their parents from a legal perspective. So, it's important, I think, for parents to keep in mind if they have adult children, for example, is that joint asset a true gift, or is it intended to fall back into the estate upon the parent's death? So I think that is something that we highlighted earlier, and I think it is something important because setting something up like that can actually be relatively easy, but the potential consequences of that joint asset can be absolutely detrimental to the estate if there's other beneficiaries in the blended family scenario that think that that asset's actually going to be part of their inheritance. So I think that's something very important that you touched on, that it often comes up from time to time with clients, and it's important for clients to think about.
Yeah, and I like the point that you make, Brandon, about it being easy to do these things, particularly if we're talking about bank accounts. Adding a child to a bank account is really easy. And there is often an impression that because you're adding the child to the bank account, it's going to pass because you've checked a little box that says right of survivorship. The case law requires that there be more evidence than that you intend to pass that bank account to that child. So again, making sure you get your estate planning advice from your lawyer, and not, I love my friends at the bank. They do so much good work, but you got to I don't give financial advice, and you want to make sure you're getting your legal advice, from your lawyer.
Great. And, when we're thinking about financial advice, and oftentimes I think we can both appreciate that clients will sometimes throw in the odd tax question, which I will be the first one to say I may not be able to answer. And I'll say clients should probably be getting accounting advice, just a second opinion on how the numbers are actually going to operate at the end of the day. So there are some important tax considerations that folks should consider when they're thinking about their estate plan. So especially for blended families, there's several important tax considerations we have here. So in Ontario, probate fees, officially known as estate administration tax, is calculated based on the value of the estate. So it's 1.5% on the value of the estate over 50,000. So effective estate planning can help reduce these fees, for example, by using joint ownership or beneficiary designations, again, keeping in mind some of the potential risks in the joint ownership arrangement between parents and adult children. So when you pass away, another consideration that you may need to think about when you're planning in your will is that your estate may be subject to capital gains tax, I should say, on the increase in the value of your assets. So this can be things such as real estate and on particular investments. So this can ultimately significantly impact the value of the inheritance that's going out to the beneficiaries. If you own multiple properties, for example, in the context of real estate, you may need accounting advice regarding which property could be designated as your principal residence. So again, a lot of clients will be thinking about, can I get an exemption on this property if it's worth more? Or, should I elect another property? These things should really be considered with an accountant, but proper planning can help minimize taxes on certain real estate properties. So again, oftentimes, accountants and lawyers and financial planners will often work together for the benefit of the client. Spouses could transfer registered retirement saving plans, RRSPs, and registered retirement income funds, or RIFs, to each other tax-free potentially upon death. However, it's important to note in the context of blended families that this benefit does not automatically extend to stepchildren or other beneficiaries. So again, it's important to let your lawyer know if this is something that you would like to set up, and if you have any obligations between a former spouse and a current spouse. Naming beneficiaries directly on RRSPs or RIFs can help avoid probate fees and ensure a smoother transfer of assets. So it's important to think about what the asset is. And one of the things Kate and I discussed when we were preparing this presentation, I'll say, is the difference between a beneficiary designation and a successor holder. So certain accounts allow folks to designate that type of account holder and who's going to be the recipient of those funds, but it is important to understand what that is and if it's available to you. So a little bit similar, but still different. Life insurance. So these proceeds are generally tax-free to the beneficiary. Can be a useful tool, as Kate highlighted, to provide for children from previous relationships, or to equalize inheritances among family members. Again, especially important in the context of blended families. Again, life insurance can also be used to cover any taxes or debts owed by the estate, ensuring that other assets can be passed on intact. We touched a little bit on trust. So when we're thinking about blended families, there may be a need for a family trust, and this potentially could help manage and protect assets for beneficiaries, particularly minor children or those who may not be financially responsible. Trusts can also provide tax benefits by spreading income among beneficiaries in lower tax brackets, for example. Again, we spent a few minutes talking about spousal trusts. So these can provide income to a surviving spouse while preserving the capital for children from a previous marriage. Charitable donations, that is something that sometimes come up in our planning, even in blended families. So you can make charitable donations through your estate, which can provide potentially significant tax credits, reducing the overall tax burden on your estate. It's important to identify which charity you're giving to. Are they registered? And working with an accountant to make sure that it is achieving the result that you desire from a tax credit perspective. So ultimately, what we're trying to get at here is that it's crucial to regularly review and update beneficiary designations on all accounts and policies to reflect your wishes and family situation. So this helps avoid unintended tax consequences and ensures that assets are distributed according to your plan.
Perfect. So yeah, just a few quick takeaways before we leave wills. Sometimes people ask me how they can change their will, if they can make changes on their will directly, or what does that process look like? If you want to make a minor change to a will, you can do that with a codicil. So for example, if you've separated and you're not ready to make big overall changes to your will, but maybe you want to change your executor, you could do that with a codicil, but more extensive changes would require a new will. And then just as you're reviewing documents, as you're reviewing your will for changes, make sure you're mindful of how property is owned and looking at your designations and keeping those up to date. So we're going to chat a little bit about powers of attorney and how those fall into the plan. So we'll start first with property, and I'll turn it over to you, Brandon.
Thanks, Kate. So, and just to remind folks, so when we're talking about an attorney, we're not necessarily talking about a lawyer. We're talking about somebody that an agent is another way of saying it, that you've appointed to act on your behalf. So there is you don't necessarily need a lawyer to also be the attorney in this context of these documents. So your power of attorney for property. So typically this gives your attorney or agent the power to make financial and property related decisions on your behalf. So what does that mean? For example, your attorney could handle financial matters like banking, check signing, real property transactions, and purchasing or selling personal effects, just as a few examples. So unless you limit your attorney's, ability to act, they can perform nearly all financial or property related actions on your behalf, except making or amending your will or appointing a new attorney to act on your behalf, just as a couple examples. So in brief, typically most people, when they come to our office, are looking for what's called a continuing power of attorney for property. So this enables the attorney to continue to act for you if you are deemed to be mentally incapable, or you are unavailable to make financial and property related decisions on your own behalf. So your attorney, this is very important to note for a lot of clients, will be authorized to act on your behalf immediately upon the document being signed by you, unless you specify a condition or restriction, dealing with their appointment. So a lot of clients or folks will ask, how much power does an attorney have? They have a lot of power to help you with your money, and they can basically make decisions without even notifying you, although it is probably recommended that they do consult with you. But their power to be able to assist you, typically speaking, is very broad. It is sweeping, and all the more reason to sit down and chat with a lawyer to make sure that you understand the person that you're appointing and what they have access to. Did you want me to talk about personal care, Kate, or?
Well, I can talk about personal care. So, your other power of attorney is going to be your power of attorney for personal care. So this is the person who's going to make decisions around your health, safety, shelter, clothing, nutrition, hygiene. They're going to make these decisions if you don't have the capacity to make them yourself. So it could be some of those decisions, it's whatever you don't have capacity to make. And so for the powers of attorney in the context of a blended family, there's sort of two things that I always talk about with clients. One, if you've separated, these are documents you probably do want to update relatively quickly, because you may not want your spouse being in charge of your finances or your personal care anymore. And the second thing that I would say is think about who your appointments are. Like, think about who the people you're appointing. So your attorney for personal care is going to have to work closely with your attorney for property. So if they're different individuals, depending on the context of your blended family, think about how they are, think about how they deal with conflict, think about how they resolve disputes, and make sure that you put some time and thought into thinking about, are these the people, if I'm not able to make decisions, are these people going to be able to work together? So that brings us to the end of our part of the presentation. We look forward to some questions later on, but first I'm going to turn it over to Anna. She's going to talk a little bit about, her perspective from the funeral home and working with blended families.
Thanks so much, Kate and Brandon, for your presentation. It was very informative and very enlightening on a lot of different issues. And to echo what you were saying, Kate, we do find situations where we're sitting in a room with blended families and there is no plan and everybody wants something different, and it causes a whole lot of confusion, and especially if it's the first family versus the second family, because everybody tries to come together and often there is miscommunication. And the one thing that I can recommend, just like you prepare your will, you should be preparing your funeral plans. And it's a good way to avoid having conflict. And I find that a lot of people will say, well, I have my plot. And so I have my plot, so my funeral plans are made. Well, it's not quite that simple. You may know where your remains are going to end up, but there's a lot more planning involved that you have to go into. And it's really easy to sit with us and to make your plans and then to share your plans with your family, because your family has to understand, especially when you're from a blended family, you want to make sure that everyone in that family understands that this is the plan that you want and this is the plan that you made. Because when you sit and make a plan with us, and even if you prepay or you don't prepay, and we have all your plans in place, your executor can make decisions to change things. So especially if you've appointed someone in a blended family that it now has the power to change things, you want to make sure that everybody knows that you don't want those plans changed. So if you share the information with everybody, then they're going to understand, this is what I've chosen, this is what I want. We have it in writing. And then they'll understand that, yes, dad or mom has done this, they've made these decisions, we need to follow through with them. We have a tool that I give when I meet with a family or an individual to make their funeral plans. And I have a book, and I'm sorry I don't have a copy here to show you, but anyone can call me and we can chat about it. And it's called My Biography. And it is, I find it an amazing tool, because in this book, there's a place for you to talk about the music you want. Who do you want to speak? Who do you want to officiate? What prayers do you want said? All of those things, and to leave some information for your children in that book as well. There's also a place in the book to leave names and phone numbers for your family, that, you know, of people you might want notified that they wouldn't necessarily know. So that's a really great tool. The other thing that I always recommend to my clients when I'm meeting with them and we're setting up their funeral plans is write your obituary. Start your obituary. At least get something on paper, because the hardest thing for your family to do in their time of grief, especially in a blended situation, is to decide what should go into the obituary. So if you want it known how you lived your life and what your life was about and how much your kids meant to you, then you should make sure that you write the obituary so that no one is left out of that obituary, and that everyone that you want recognized that was a part of your life, their name is in that obituary. The other thing I also recommend is that you pick the photo you want to go along with your obituary and send that to me. They sit in the room and, well, we want a photo from back then, or we want a photo from now, or so there's all that kind of stuff as well. So those are some of the things that I recommend when planning. And I have to tell you, I've never had anyone said to me, oh, I'm sorry my dad or mom made their funeral arrangements. Trust me, those words never come out of anybody's mouth. They are overjoyed when they sit in front of us and everything is in place and everything is set. And that's really important. The other thing too is, you know, if you made your funeral plans 20 years ago, things may have changed. You may want something different. So you should update when you're updating a will, you should then review your funeral plans as well and make sure that they are still are what you want. And if you have an obituary on file with us, maybe you want to update that as well. So there's all those kinds of things that are really, really important. But one of the most important aspects is always to include your family in what you're doing. Kate, a couple of things that I thought about when you were giving your presentation, you and Brandon, were what happens when a lawyer is the executor, and then who plans what time the funeral is going to be and where, you know, those kinds of things. So maybe you can touch on that a little bit, and what you recommend in those situations, because often if someone passes away, if the lawyer is the executor, we can't get a hold of the lawyer for, you know, 2 or 3 days if it's not office hours. So do you want to kind of touch on what your recommendation around that is?
Yeah, sure. So, you know, whether it's a lawyer or an individual, you know, as the executor is the one who is responsible for funeral plans and all of this. Generally speaking, if the lawyer is the executor, they're going to defer to what the family wants in terms of the funeral, the time, and all of that. So unless there is a dispute between the family members as to what should happen, then ultimately, you know, deference is going to be given, of course, to the family members. So I think it really goes to your point about having a plan in place, you know, to avoid having some of those disputes come up. Because if everything is planned, then, you know, whether it's the lawyer or somebody else who's the executor, things are going to run smoothly. I have had, you know, situations where not as much with the planning of the funeral, but there can often be a lot of dispute over what happens with the remains, particularly obviously where there's been cremation. And so that is something really people should turn their mind to, and they can express their wishes in the will or with you guys to make sure that it's abundantly clear what they would like to have happen with their remains. Ultimately, it will be up to the discretion of the executor. So if that's the lawyer is going to be in charge of determining how those are dealt with. So the more detail you can give, the better.
That brings up a good point, Kate, when people choose cremation and they sit in front of me and say, you know, this is what I want cremation. One of the conversations I always have with them is, what is the plan for your remains? Because often people think, you know, oh yes, I want cremation, but they don't think past that.
Yeah.
You know, what they actually want to do with them. So that's a good point. Thank you for that. We have a few questions here, so maybe we'll shoot to some questions. The first one is, my step-in-laws live in Ottawa but have a cottage in Quebec. Should they have a will both in Ontario and Quebec?
So that question comes up regularly for us being on the border. I have a discussion with my clients, you know, it's definitely easier if you have a will in Quebec to deal with the cottage, for sure. But I say to my clients, you know yourself too. So if you're the kind of person who's going to leave my office and you're never going to go and do that Quebec will, because it took you enough just to come here to my office to get this will done, then let's deal with it in the Ontario will, which is possible. It just makes things simpler and probably a little bit less costly on the other side if you deal with it in an Ontario will, but best to deal with it somewhere.
Good point. Good point. Next question. I'm my mother's executor, but I am away for a number of months in the winter. In the event of my mom's death, can I authorize a family member or a friend to work with the funeral home on my behalf where necessary?
So if you're the executor, you can delegate tasks, but you can't delegate decision making. So I don't know how you guys would treat this, Anna. Like, would you be looking to the decisions, but sort of be dealing with the nitty gritty with the family member on the ground?
So what I always recommend when I get asked this question, because doing pre-planning, you know, when people are going away and they anticipate something might happen when they're gone, we often have these conversations. And what I suggest to them is they make a letter to me with those instructions and sign it, and that we have a copy and the person they're assigning have a copy, but it's only to give us permission to bring the person into our care, so that wherever that person passes away, that we can then bring them into our care. Because even if someone is traveling within a short time period, with the way communication works these days, we can always get in touch, and you can always do your documents on, like, we can always use DocuSign and get you to sign the necessary documents. But you can appoint someone to say, yes, my sister's away. She's given me permission. You have it in writing that she's given me permission to say, yes, you can bring mom into your care.
Perfect.
That's the way we approach it. So, is there a benefit to prepaying for my funeral? I'll answer this one. So we will take pre-arrangements from anyone who wants to make sure their plans are in place and have their obituary done and their photo done. The advantage to prepaying for your funeral is you're paying in today's dollars. So you're never going to, if you don't use the service for another 10 years from now, you're never going to have to pay more than what you pay in that time. And the money sits in a third-party trust. The money does not belong to the funeral home. And we then are given the funds when it's time for the funeral and the services to take place. So I hope that answered a question. If anybody wants more information on that, I'm happy to have them reach out to me, anna.silverman@hpmcgarry.ca, or call any one of our offices and they'll get a message to me to reach out to you. What help with estate issues does the funeral home provide? So I can tell you that one of the things that we provide with all our services is we will meet with the executor after the funeral has happened, and we will help you apply for the death benefit, cancel the pensions, cancel passports, driver's license, health cards, that kind of thing. Anything that needs to be more legal than that, then you have to turn to your lawyers. But for the basic government forms that need to be done, we assist with that. Do you want to add anything to that, Kate or Brandon? No, you're good?
No, I think that's good. I mean, I think it's always, in speaking with clients, it's often, that's a service that they really, really appreciate, because in those days, immediately when they're dealing with a death, they're not often coming to us until, they might come to us just for the will, but they're often not in the space to meet with us until some time has passed. So I know a lot of clients really appreciate that.
So when somebody is sitting with you to do their estate planning and they ask you about planning their funeral, what is your recommendation about not putting it in their will?
So, clients come to us with so many different approaches on this, and I think the biggest issue for most clients is that they haven't thought of it, and they don't want to think about it. So we have to do a little bit of work up front to encourage them to think about it. And some of them with us, they're not ready to put it in their will, even if we encourage them to do that. So I will also tell clients, if you're not ready right yet, if you want to get this will signed and you need more time to think about it, make sure you do a letter. You should always be doing a letter to your executor about what your wishes are. You can do a letter about a lot of things. You can do a letter about, to the guardians for your kids, how you would wish trust funds to be used for them, and then how you would want your funeral to be done. So I know it's a difficult topic, and Anna, you probably, have this conversation with clients all the time. Like, thinking about death is really, really challenging. But the clearer you can be and the more places you can put your wishes and put them consistently, the better.
One of the, while we're chatting, Kate, I'm just going to encourage anyone who has a question to please pop it into the chat and we'll try and answer it for you. One of the things that I find is that people come in to meet with me to talk about their funeral arrangements, and when they first sit down, they're a little bit uncomfortable. They don't know what to expect. I can tell you that it's a very easy conversation. It's a dialogue back and forth. What are you thinking? Can I advise you one way or the other? And to help them think about things that they hadn't thought about. And 9 times out of 10, when they walk out of the office, they go, "You made this so easy for us." We were dreading doing this, and you've just made it so easy because it's just a dialogue. It's not, no one has passed away. There's no angst or anxiousness about it. Just come and chat with me and let's get something down on paper. Easy
Yeah.
peasy, you know, comfortable situation.
Yeah.
What is the difference between a living will and mandate? I'm
Okay. So
originally from Quebec.
they had mandates. Yeah. So I don't know exactly what goes into a mandate. So I can't answer what the difference is, but a living will is a document that would express, you know, your wishes if there's no reasonable chance of your recovery. What are your sort of end of life wishes? Do you wish life support to be removed, etc.? Now, it's different than an advanced care directive, which is a much more detailed medical plan for what would happen in certain medical instances. And in that case, I recommend people to discuss an advanced care directive with their physicians and their care team, because that sort of goes beyond the scope of what we're able to do. But I also talk to clients about the Dying with Dignity website that has a lot of good information on end of life, planning and advanced care directives and things like that. So that's a great resource for people who have more questions about that kind of documentation.
That I know this is something that you touched on, and someone's asking for some clarification about joint registration on assets with adult children and parents.
Sure. So you can own property with children. You can, so real property, you can own bank accounts with children, like you can own anything with children. But you need to be careful that your intentions with that are clear. So when you own property jointly with a spouse, it passes to them by right of survivorship if it's owned as joint tenants. With adult children, the presumption, if that child has not, paid for the property, if they're not contributing to the account, if it's not a true joint asset, you're just adding them to title, then the presumption is that it reverts back to your estate entirely. Now, sometimes people are adding children to certain bank accounts, etc., because they want them to receive that account on death. They need to create additional contemporaneous evidence. We will often do like a statement of intention. I intend for this joint account to pass to blah, or I intend not for this. Like whether it's pass or not pass, we want to be clear. You do not need to add your children to accounts for them to manage it. You need a power of attorney document. You can appoint them as your power of attorney, but you don't need to add them to the account for them to properly manage. Now, clients will ask me, oh, well, I should add my child to my account because I'm afraid that when I die, they won't have access to my accounts to pay things. But the banks will release funds for many, many things, for funeral expenses, probate fees, if there's, ongoing expenses that, have to be paid, insurance on a house, etc. The banks will release those funds. So, be very cautious, proceed with extreme caution before adding people to assets. Hopefully that clarifies things.
Yeah. There's a question here about, and I'm not sure what, I'm going to read it, but I'm not sure that we understand exactly what they're asking. How is someone determined not competent and the POA, property and personal care?
Great question. So first you have to look to the document. So for a power of attorney for property, you could have it be conditional or unconditional. If it's conditional, it means it's conditional on your incapacity. So that document will only be able to be used if your attorney can prove that you're incapable. And so that will typically be by way of, letters from a physician, very hard to get in a lot of cases, or a certificate of incapacity from a capacity assessor. So that's how the power of attorney for property, if it's conditional, would be invoked. If you have an unconditional power of attorney for property, the attorney can act notwithstanding that you may still have capacity to manage your finances. So it could be on your request. It could be, they see, mom or dad is starting to have cognitive issues, and they start to step in as the power of attorney, or as the attorney for property rather, to start managing things. On the personal care side, it's always conditional, right? It's always dependent on your lack of capacity to make a personal care decision. And in that case, it's typically going to be oftentimes a physician or someone on a care team saying, so-and-so does not have the capacity to live at home anymore. They need to go into care, or they don't have the capacity to decide about whether or not they should have this surgery. So that's usually going to be a physician.
Well, I can't tell you how much information everyone out there listening has gotten the same level of information that I have. I think it's great, and I can't thank you and Brandon enough for your time and for such informative information. Um, all I can say is make sure you make your will. I personally believe in pre-planning your funeral because it will save a lot of hassles down the road. And as I said before, I've never had any child sit in front of me and say, "Oh, I wish my parents hadn't have done this." Like, it is the best gift, Brandon, as you were talking about a will be a gift. It is the best gift you can leave your children, is to make sure your plans are in place. So no one has to say, did mom want this or did mom want that, or what, and there's no discussion. It's there and it's done. And thank you again for joining us this evening. And I hope that everyone watching and joining us tonight got a lot out of this. And we will send you a recording of it. Whoever was here tonight will send you a recording of tonight's, and then it will get posted eventually on our website. So anyone, you can recommend to your friends that they go listen to it as well. Thanks again, and I wish everyone a good night and good health. And please do reach out to either Kate or Brandon and myself for any future advice you may need.
Thank
Thank
you so
you.
much, Anna.
Thank
Thanks
you.
for having us.
Our pleasure.